the Honorable, the Chief Justice, and the Associate Justices of the Supreme Court of the Philippines. Hear ye, hear ye, hear ye. All persons having business before the Honorable, the Supreme Court of the Philippines shall give their attention, for the court is now in session.
The Clerk of Court will please call the matter at hand.
Yes, Your Honor. Continuation of the oral argument in the following consolidated cases. GR number 231658, Representatives Edsel C. Lagman et al. Versus Honorable Salvador C. Mejaldea, Executive Secretary et al. GR number 231771, Eufemia Campos Colyamat et al. Versus President Rodrigo Duterte et al. And GR number 231774, Norcaya S. Muhammad et al. Versus Executive Secretary Salvador C. Mejaldea et al. Appearing as counsel for petitioners in GR number 231658 are Congressman Edsel C. Lagman and Attorney Edsel Greco A.B. Lagman. Appearing as counsel for petitioners in GR number 231771, Attorney Nery J. Colmenares, Attorney Ephraim B. Cortez, and Attorney Maria Cristina P. Yambot. Appearing as counsel for petitioners in GR number 231774, Attorney Ray Paulo J. Santiago, and Attorney Marlon J. Manuel. Appearing as counsel for respondents from the Office of the Solicitor General, Solicitor General Jose C. Calida, Assistant Solicitor General Vida G. Vicente, Assistant Solicitor General John Emmanuel F. Madamba, Assistant Solicitor General Rex Bernardo L. Pascual, Assistant Solicitor General Marisa Macaraig Galien, Assistant Solicitor General Hermes L. Ocampo, and Assistant Solicitor General Henry S. Angeles. Thank you, Your Honors.
The counsels will please take their seats except for Attorney Marlon Manuel, and I will begin the interpellations with him. Kindly please proceed to the microphone, to the podium.
Good morning, Your Honor.
Good morning, Attorney Manuel. Yesterday, you were espousing the theory that Article 7, Section 18 is a completely different proceeding. That's why it was in that sense that it is special.
Yes,
Not
Your Honor.
that it is one of those that are enumerated in the rules of special proceedings, but because it is special. It is unique, it is sui generis.
Yes, Your Honor.
Now, Section 1, Article 8 provides that the judicial power shall be vested in the Supreme Court and such other courts as may be created by law. Now, it is an all-embracing statement, and the second paragraph of that section talks about what judicial power includes.
Yes, Your Honor.
And the first phrase, or the first set of ideas there, is the power to settle actual controversies governing rights
Yes, Your Honor.
that are legally demandable. And that goes into your traditional concept of causes of action. And the second part of that same paragraph talks about grave abuse of discretion on the part of any government agency.
Yes, Your Honor.
And we have already in many occasions said that that is apart from Rule 65, the Rule 65 proceedings that are described under the rules of court.
Yes, Your Honor.
And I also note that Section 5 of the same Article 8 provides in paragraph 5 that the court has the power to promulgate rules for the protection
What the Constitution has authorized the Supreme Court to do.
It is, would you agree, therefore, that it is only commonsensical that the rules of procedure follow what the Constitution designs, because we could not have promulgated rules for the protection of rights unless they are first defined by the Constitution and by appropriate legislation?
Yes, Your Honor, we agree.
So if this court is fully empowered to take cognizance of a proceeding that is entitled in re petition under Article 7, Section 18,
Yes, Your Honor.
because it is provided not by our rules of court but by the Constitution itself.
Yes, Your Honor.
And this court actually has the constitutional duty to ensure that rules do not derogate from substantive rights. And that has always been a principal rule in any interpretative duty that we have.
Yes, Your Honor. Rules are essentially procedural in nature.
They are procedural, and the rules are always to be construed so that the ends of justice may be achieved.
Yes, of course,
Is that
Your Honor.
correct?
Yes, Your Honor.
And considering that we have already, in many instances, already promoted the concept of issues of transcendental importance that will allow us to take cognizance of actions, more so should this court exercise its duty when it is specifically defined under a specific provision of the Constitution. Is
Yes,
it correct?
Your Honor. Yes, Your Honor. The transcendental importance has been identified specifically by Article 7, Section 18.
Now, the other problem that, you do not believe that you therefore have to satisfy either the requirements of the second paragraph of Section 1, first phrase, actual cases involving rights that are legally enforceable, nor do you have to satisfy the requirement of grave abuse of discretion, nor do you have to satisfy the requirements of the existing rules as promulgated by this court.
Yes, Your Honor.
Is that your theory? Do I take it clearly?
Yes, Your Honor. We anchor our petition on specifically on Article 7, Section 18.
All right. I have no further question for you, Attorney Manuel.
Thank you, Your Honor.
Is there any other justice? Justice Hardeleza, please.
Good morning, Your Honor.
Madam Chief Justice. May I request Congressman Lagman, please?
Good morning, Your Honors.
Good morning, Congressman Lagman. I just want to confirm your statement yesterday that this court, in determining the factual basis for the declaration of martial law and the suspension of the writ of habeas corpus, is bound by the, I think your words were the four corners of Proclamation 216 and the report of the President.
We respectfully submit, Your Honor, that that was our position. It is a continuing position that the assessment of this honorable court on whether there is sufficiency in the factual basis of the proclamation as well as the suspension should be within the periphery of these two important documents of the President.
And I agree with you, Congressman Lagman, on that. And permit me now to very briefly just go over the two documents on matters of fact, and then I will ask you, just for clarification, whether the petitioner, you or the others, essentially admit or you deny or you have no knowledge of facts as alleged by the government. So can you please have your copy of Proclamation 216?
Yes, Your Honor, I have my copy.
The last, the fourth whereas clause says Proclamation number 55 was issued because it was of the violent acts committed by the Mautet terrorist group. You admit it is a terrorist group?
May I be enlightened as to what whereas is that, Your Honor?
The fourth whereas, Congressman.
1, 2, 3, 4. Yes, Your Honor. Which starts with part of the reasons for the issuance.
Yes?
Yes, Your Honor.
The Maoti group is a terrorist group.
Yes, Your Honor. We
Yes.
agree that it's a terrorist group,
It-
and it should be subdued by the armed forces of the Philippines.
Well, it launched attacks in Butig, Lanao del Sur in February 2016,
Yes, Your Honor.
and it conducted a mass jailbreak in Marawi City, August 2016.
Yes, Your Honor.
Now, the
But
next...
those facts do not constitute actual rebellion.
Well,
As a matter-
with your kind indulgence, Congressman, so that we do this very quickly, essentially I'm asking for confirmation whether you admit, deny, or you have no knowledge, and then you will be free in your memorandum to argue your points. The next whereas clause, please. It says on May 23, 2017, the Maute Group had taken over a hospital.
We deny that allegation, Your Honor, because subsequent events showed that the hospital was not taken over by the Maute Group.
Subsequent events.
Yes, Your Honor. Because there was a statement from no less than the director of the hospital that the hospital was overrun by the Maute groups and the medical personnel were not taken as hostage. The hospital is operational and has not been disrupted.
The next statement is Maute Group established several checkpoints within the city.
Well, we can assume that occurred.
Burned down certain government and private facilities.
Your Honor, this is a general statement which should be specified because there were statements no less from the military establishment that those facilities which were reported as burned down has not been actually burned down.
We will go to that later when we go to the report of the President. That flying of the flag of ISIS in several areas.
Yes, Your Honor. That is cheap propaganda.
Well, you admit that the flag, the ISIS flag, was flown.
Yes, Your Honor.
Yes. Now, the next whereas clause, please. The recent attack shows the capability of the Maute Group to conduct terror not only in Lanao del Sur but in other parts of Mindanao. As a statement of fact, do you admit or deny or you have no knowledge?
It is a conclusion of fact, Your Honor.
So, do you have facts showing otherwise?
Your Honor, there are verifiable facts that there is no rebellion or invasion in other parts of Mindanao.
No. It says capability to sow terror not only in Lanao but also in other parts of Mindanao. So it's capability.
That's a possibility which is very subjective, Your Honor.
Can you please go now to your copy of the report of the President?
Yes, Your
Do
Honor.
you have it?
I have the copy.
Now, this report is of course signed by the President.
Yes, Your Honor.
Yes. So, the first paragraph around the fifth line, says the lawless elements for the purpose of removing Mindanao from the allegiance to the government. Is this a statement to which you agree?
No, Your Honor, we
you-
dispute that statement. That is a conclusion of fact and law.
We'll go now to page 3. Do you have page 3?
Yes, Your Honor.
The first paragraph, the first sentence, Mindanao has been the hotbed of violent extremism and a brewing rebellion.
Well, Your Honor, the history of Mindanao would show that it has been a hotbed of extremism and terrorism.
Not of brewing rebellion?
Your Honor, we could not say that because rebellion has specific elements.
The last sentence, Congressman Lagman, two armed groups have figured prominently in this, the Abu Sayyaf group, ASG, and the ISIS-backed Maute group. First, two armed groups, ASG and Maute group. Do you admit or deny that they have been committing acts of violence in Mindanao?
We admit that they have been committing acts of violence.
The statement that Maute is ISIS-backed.
We do not agree with that, Your Honor, because that is a conclusion of fact and law.
And from your point of view, what is the fact on this? It is not?
The fact is, this Maute group is trying to get the support of ISIS. It's trying to affiliate with ISIS, but there has been no confirmation from ISIS itself that it has been so recognized.
Can we please go to the next sentence? On May 23, a government operation was to capture Isnilon Hapilon.
Yes, Your Honor, that is
Yes.
true.
But then the government met with resistance, and which led to the paralysis of Marawi City.
Well, the armed resistance to shield Hapilon from capture or arrest, we agree. But with respect to the paralyzation of Marawi City, that is another conclusion of fact and law.
What is your description of the kind of, what was the effect of the resistance of the armed group, if not paralyzation?
There was disturbance. There were terrorist acts, but not amounting to rebellion.
The last sentence, the sudden taking of control was intended to lay the groundwork for the establishment of a Daesh or province.
We do not agree to that, Your Honor. That is another conclusion of fact and law.
The next paragraph, please, it says, based on intelligence report, as of the end of 2016, Maute Group consisted of around 263 members, fully armed, prepared to wage combat.
Well, that is the data coming from the military, and we have no basis to refute that small contingent.
Well, essentially, you have no knowledge.
We have no knowledge. Your
But you're saying it's a small contingent. Do you have facts as to how small?
Well, it says 263, Your Honor.
The next sentence says, the group operates in Lanao del Sur but has extensive networks and linkages with foreign and local armed groups such as Jamia Islamia, Mujahidin Indonesia Timur, and ASG. Do you admit or deny, or you have no knowledge of this?
Well, this is another conclusion of fact and law, and Your Honor, it is for the respondents to substantiate this
substantiate.
allegation.
It adheres to the ideals of Daesh as evidenced by a video footage declaring its allegiance to Daesh. Do you admit that there is that the Maute group has professed its allegiance to Daesh or ISIS?
Well, we could grant that, Your Honor, but allegiance is a two-way traffic. One can publicize its allegiance, but it depends on the other party whether to admit or support such statement.
Thank you. Can you please go to page 4? This is now the part of the report of the President where he starts the narration of the events that happened on May 23. At 1400 hours, I think that's 2 o'clock in the afternoon, members of the Maute groups attacked Marawi City. Do you admit that it started at 2 o'clock?
We have no personal knowledge of this, but we could always refer to the statements of the military that before the issuance of proclamation number 216, the military was under control of the situation.
Well, I think by the time I will be asking the Solgen, the statement of the government in its comment is that the operation started at 1:30 in the afternoon. And the reason, Congressman, that I am trying to fix a common timeline between you and the government is that if it started at, assuming 1:30 or 2 o'clock, then to your knowledge, what time did the President sign Proclamation 216?
Well, Your Honor, it was at about 11:20 in the evening of May 23, 2017.
Well, subject to what the government will say, well, you know, it's 1:30 or 2. Assuming for the sake of argument, it's 2 o'clock in the afternoon, and he signed at 11, so he had 9 hours. He proclaimed martial law and suspended the writ 9 hours after the hostilities started. So that's one of the things that I would like to have a view, and ideally, if you agree with the government on the timelines, that will make the job of the court a little bit easier. But can I go ahead? By 16:30, that means 4:30, power supply was cut.
We have no personal knowledge whether
From
to confirm
1800
or
to
deny this.
1900, which means from 6 o'clock to 7 o'clock, the Marawi police station was burned.
We deny that, Your Honor, because there are subsequent reports that didn't happen.
A patrol car of the police station was taken.
I beg your pardon, Your Honor.
It says a patrol car of the police station, meaning the Marawi station, was taken by the group, Maute group.
We are not personally aware of such alleged fact, Your Honor.
Now, by the evening of May 23, it does not specify the time or the hour. At least 3 bridges, namely Lilod, Bangulo, and Sauran, fell under the control of these groups. Do you admit that? Or?
We cannot make any comment on that, Your Honor, because we are not aware of this circumstance.
And that the Maute group threatened to bomb the bridges to preempt military reinforcements.
We are not
You have
aware
no
of that.
knowledge. Now, it says at 22:22, and I will be asking the Solgen whether this is a typo, because 22:22 literally means 10:22 in the evening. Persons connected with the Maote group had occupied several areas, including then, and this is very important, they're saying that by 22:22, Maote group had occupied 4 streets: Naga, Bangolo, Bapandi, and Camp Keithley, and occupied the following barangays. There are 13. Basak, Malulot, Mapandi, Sadok, Dilod, Bangon, Saber, Bulong, Barantao, Caloocan, Bangolo, Barrio, Naga, and Abubakar. So, the assertion is that by 22:22, the Maote group had occupied 4 streets and 13 barangays.
We are not aware of this, Your Honor. It would be for the respondents to validate this statement, but granting that this statement is true, it will not constitute actual rebellion.
These lawless groups had set up roadblocks and checkpoints at the Iligan City, Marawi City Junction.
We are not aware of this, Your Honor, but we could grant that this happened.
The Maote group burned Dansalan College Foundation. That's on page 5, Congressman.
5.
On the top of page 5, if you may.
Well, this has been subsequently denied, Your Honor.
Burned Cathedral of Maria Auxiliadora.
We are not aware of that, Your Honor.
Burned the nuns' quarters in the same church.
We are not aware of that, Your Honor.
Burned Shia Masjid Moncado Colony.
Likewise, Your Honor, we are not aware of that.
Hostages were taken.
We are not aware of that, Your Honor, but all of this would not constitute actual rebellion.
5 faculty members of Dansalan College Foundation were reportedly killed.
We are not aware of that, Your Honor.
Senator Ninoy Aquino College Foundation was burned.
Your Honor, we deny that that factual assertion because actually the Ninoy Aquino College Foundation has not been burned.
Marawi Central Elementary Pilot School was burned.
Yes, Your Honor, we do not agree to that, and we deny that because no less than the division, the deputy division head of Marawi City said that this did not happen.
Maote group attacked Amay Pakpak Hospital.
We deny that, Your Honor, because subsequent events would show that the Maote group did not attack.
Hoisted the ISIS flag there in the hospital.
That is a possibility, Your Honor.
Because your position is they did not attack. They entered the hospital to bring wounded, right?
Yes, Your Honor. They entered the hospital with the permission of the hospital authorities to bring a wounded comrade. And according to the report, they were very respectful, and they even asked that they be allowed to pray inside the hospital.
As of 600 hours, or meaning 6 in the morning of May 24, this is already May 24, the next morning, members of the Maote group were guarding the entry gates of Amay Pakpak.
Well, they were there just to bring their comrade who subsequently died.
They held hostages, employees of the hospital.
No, Your Honor, that is not true.
They took over PhilHealth office in the hospital.
We are not aware of that, Your Honor.
The group likewise seized another hospital, Filipino-Libyan Friendship Hospital, which they later set ablaze.
We are not aware of that, Your Honor.
Ransacked the Land Bank of the Philippines.
Well, no less than the land bank said that land bank was never ransacked by the terrorists.
Commandeered one of its armored vehicles.
The armored vehicle did not belong to land bank. It belonged to a third-party provider, and the armored car was empty.
Now, Now, the next statement of the President is, latest information indicates. Now, remember this report was submitted to the Senate and the Congress and the lower house within 48 hours, right?
Yes, Your Honor.
So, it says here, latest information indicates, which means at any time before the report was submitted, 48 hours after 2 o'clock of May 23, it says, do you see the bullet point, the third bullet point from the bottom?
Yes, Your Honor. I am...
75% of Marawi has been infiltrated by Maute and ASG.
Your Honor, this is a very subjective assessment, and it is a conclusion of fact.
Do you have facts otherwise?
We do not have facts otherwise, but definitely in this report there are no facts to substantiate that 75%.
Next bullet, the groups are searching for Christian communities to execute Christians,
We are not aware of this statement, Your Honor.
forcing Maranaos from leaving their homes and forcing young males to join their groups.
We are not also aware of the veracity of this report.
That the group has gotten to be a strategic mass to perpetrate killings.
We are not certain as to the veracity of this report, Your Honor, but definitely this would not constitute actual rebellion.
Can you please go to page 6?
Yes, Your Honor.
The first paragraph, please. These activities is an attempt to establish a group seat of power in Marawi City for the planned establishment of a Daesh.
There are no validation of this statement, and it is not based on adequate facts, Your Honor.
Can you please go to the third paragraph? The groups were attempting to deprive the president of his power as president to spreading their control over the entire Mindanao.
We cannot agree to this conclusion, Your Honor, because what is true is that the chain of command, both in the civilian and the military, have not been broken, and that the LGUs in Marawi City as well as the rest of Mindanao are operational.
Can you go to the second to the last paragraph from the bottom? The taking up of arms was with the support provided by foreign-based terrorists.
Again, Your Honor, this is a mere conclusion of law and fact, and there are no adequate or sufficient factual basis for this statement.
Supported by illegal drug money,
With the same answer, Your Honor.
the acts will embolden other armed groups.
The same answer, Your Honor.
There is a strategic, the next paragraph, please. The occupation fulfills a strategic objective that because of the terrain and easy access it provides to other parts of Mindanao. And these groups have historically used provinces adjoining Marawi City as escape routes, supply lines, and backdoor passages.
We could grant that these were used previously as backdoor passages, but the rest of the statement, Your Honor, we dispute because there is no factual basis for this statement.
Considering the network and alliance building activities among terrorist groups, the Seeds of Marawi is a vital cog in attaining their long-standing goal of taking control over the entirety of Mindanao.
Again, this is self-serving conclusion of fact or law, and there is no factual basis for this statement in the President's proclamation or in this report.
Can you please get your copy of the comment of the government? And Madam Chief Justice, if the good congressman would like to just sit down, that will be, I think, fine. with the court.
Congressman, the seat has been prepared. Attorney Lagman will please assist him.
I have now a copy, Your Honor.
Yes. Can you please turn to page 5? Paragraph 9. There are 4 ISIS-inspired groups that operate in different parts of Mindanao. Footnote 14, it cites Institute for Public Analysis. Do you admit or deny, or you have no knowledge of this?
Well, Your Honor, we have no factual knowledge of this, but the ISIS-inspired is an affiliation which is self-serving and has no factual basis.
Can you please go to page 6, paragraph 11? In April 2016, ISIS weekly newsletter, Al-Naba announced the appointment of Abu Sayyaf leader Hapilon as the emir or leader of all ISIS forces in the Philippines.
We are not aware of that, Your Honor, and that appointment is self-serving because it does not refer to any appointment made by ISIS.
The next sentence, the government states the appointment of Hapilon as its Philippine emir was confirmed in a 21 June 2016 video by ISIS entitled "The Solid Structure." And can you please note footnote 15? That is the CD containing the video clip entitled "The Solid Structure." So this is the evidence being presented by the government to prove its allegation that Hapilon was so appointed.
We will have to go into that, Your Honor.
Have you played I would assume that the government has supplied you with this.
I think so. My staff has told me about it, but I have not gone over it yet, Your Honor.
The next paragraph, please. Page 12. On December 31, 2016, Hapilon and 30 others of his followers, including 8 foreign terrorists, were surveyed in Lanao del Sur.
Page 12.
Paragraph 12, I'm sorry, Congressman.
Paragraph 12.
Still the same page, paragraph 12.
Yeah, to go. Yes, Your Honor, I have now paragraph 12.
Paragraph 12, it says, on 31 December 2016, do you see that?
Yes, Your Honor.
Hapilon and about 30 of his followers, including 8 foreign terrorists, were surveilled in Lanao del Sur.
We are not aware of that, Your Honor, but this occurrence is far distant from the proclamation.
I have no further questions. Congressman
Justice
Lagman.
Tinam.
Good morning, Congressman Lagman,
Good morning, Justice Dian.
whom I truly admire. He is a congressman from the Bicol region. And also the lawyers for the petitioners, I commend you for your passion, your advocacy. Congressman, you seem to insinuate that the government has to prove the existence of rebellion to satisfy the requirement of proving the sufficiency of the factual basis for the declaration of martial law. You are asking, therefore, this court, which is not a trier of facts, to look into the evidence, to gather all of the facts, to compel the parties to submit all factual evidence for us to arrive at a conclusion. Either there is rebellion or there is no rebellion. And if there is rebellion, then there is sufficiency of legal basis. And if there is no rebellion, then there is lack of sufficiency in legal basis. That seems to be the thrust of your argument.
Your Honor, it was the government through the President which alleged the existence of rebellion.
You want us
As-
to...
can-
there
can-
are
can I
there have
just-
been cases filed
Can I
against...
just continue, Your Honor?
Yeah, I just wanted to interject. There have been cases filed against suspects charged with rebellion. If you suggest that this court make a conclusive determination that there is either rebellion or there is no rebellion, will that not preempt the prosecution of these people by the trial courts?
We are not asking the Honorable Court to do that, Your Honor. What we are asking is for the Honorable Court to exercise its mandated jurisdiction under the third paragraph of Section 18 of Article 7 with respect to determining the factual basis of the declaration of martial law. Since it was the government which alleged that rebellion was a factual basis for the declaration of martial law, then it would be incumbent for the government to show that, in fact, rebellion existed. And we are not going to make any factual determination may we submit outside of the periphery of the two important documents, the Proclamation number 216 and the President's report. Those two reports would show whether there is actual sufficiency of factual basis for declaring martial law and suspending the writ, Your Honor. And as far as we are concerned, it is the submission of the President that there is such a factual basis, but a verification of the report as well as the proclamation would show that there is actually no factual basis with respect to the occurrence of rebellion, because there is no statement here wherein the culpable purpose is based on factual reports, and also with respect to the necessity of securing public safety, which are requirements under the Constitution.
May I ask you a personal question, Congressman Lagman? Did you vote for President Duterte during the last election?
Your Honor, may we submit that might not be material?
I'm trying to establish something.
That might not be material, and that would
All right.
destroy the sanctity of my vote.
Okay, I'm sorry. All right. If you did not vote, in other words, my question leads to another question. Do you trust this president to use the powers under the Constitution to declare martial law to do it fairly, reasonably, and legally?
Unfortunately, Your Honor,
You
I
cannot.
do not.
All right.
Because
Now,
of,
going back to my
ca-
second question,
could I
had
explain-
you voted for somebody else, and that somebody else became president, and faced with the same situation, also declared martial law, would you have supported that president?
Your Honor, may I refuse to answer that hypothetical question?
All right, I will go directly to the point. Is it not a fact that you filed this petition because you are against the declaration of martial law per se?
No, Your Honor. We filed this petition on the basis that there is no sufficient actual basis for the declaration of martial law. If there was sufficient actual basis, we are not going to file this petition.
I have listened for so many hours to the arguments of the petitioners, and I have repeatedly heard petitioners' counsel saying there is no necessity for martial law, and there was also an exposition of the evils of martial law in the past, and that it is prone to abuse, and the fact that martial law should be the last resort. I have heard that repeatedly. What kind of a situation would entail a last resort?
Well, Your Honor, if we read the Constitution, the reaction, the response of the President with respect to emergencies of this nature would be calibrated. The first is to call the armed forces of the Philippines to subdue lawless violence, invasion, and rebellion.
There is
If that fails, then the President has the other option to suspend the writ of habeas corpus. And if that still fails, then the President can now declare martial law as an act of final resort.
There is nothing reprehensible with the power of martial law under the Constitution.
Definitely, Your Honor, because the proclamation of martial law by the Chief Executive is acknowledged in the Constitution. But there are multiple safeguards provided for in the 1987 Constitution to prevent the recurrence of the abuses and atrocities of martial law, reminiscent of the Marcos martial law regime. But those safeguards, Your Honor, will only be good in the hands of a president which respects the law and respects the Constitution.
Is it possible that one of the motivations for filing these petitions was because of the fear, the apprehension that this president might abuse the powers of martial law?
Yes, Your Honor, that is a part of our petition, the apprehension that despite the safeguards in the Constitution, the safeguards may be violated by a president who may not respect the law and the Constitution. And we have already evidence of that, Your Honor, with respect to the extrajudicial killings related to the ongoing deadly campaign against drugs, and also the statements of the president which would embolden the soldiers and the military to commit excesses, including the crime of rape.
This aversion towards martial law carries a human rights dimension. Now, in filing these petitions, whose human rights are you seeking to protect?
The people's human rights, Your Honor, particularly the residents of Marawi City. And we have already the report of the IBP Lanao del Sur, which documents the unprecedented violation of human rights and human rights and civil liberties in Marawi City. We are going to attach a copy of that correspondence addressed to the President by the IBP Lanao del Sur.
So I'm sorry, those incidents you cited were not part and parcel of the petitions you filed with this court?
Well, not explicitly, Your Honor, but this can be subsumed under our averments in the petition.
All right, let me go to another matter. And this was raised earlier by Justice Velasco. Under Section 18, Article 7 of the 1987 Constitution, the provision provides that the Supreme Court may review inappropriate proceedings. I've gone over the members of the Constitutional Commission which drafted the 1987 Constitution. I see the names of Cecilia Munoz Palma, Ambrosio Padilla, Adolfo Ascuna, Jose Benson Jr., Joaquin Bernas, Hilario Davide, Jose B. Laurel Jr., Christian Monsod, Blas Ople, Florence Regalado, Francisco Rodrigo. I do not think these people of wisdom, of discernment, of foresight and vision would use imprecise language recklessly. What in the arguments I heard earlier, one of the lawyers mentioned that the review by this court should be automatic despite the fact that the Constitution uses the phrase may review. What are your thoughts on this, Congressman?
Your Honor,
Can we decline to give due course to this petition?
Your Honor, as far as the talent and wisdom of the drafters of the Constitution, which you have mentioned, we agree with you, Your Honor. But because of that talent and wisdom, they crafted Section 18, Paragraph 3 of the Constitution, which grants to this honorable court that jurisdiction to review the factual basis of the declaration of martial law. And it says any citizen can do that. You know, that citizen may not even appear before this honorable court through counsel. All that he has to do is the filing of the appropriate proceeding under this particular section, verify it, and make a statement of non-forum shopping. That would be sufficient. Now, Your Honors, we believe that we have filed the appropriate proceedings, and we believe that the Supreme Court should give due course to this petition, and no less than the Constitution provides, just to emphasize the urgency of this mandate, that the decision of the court should be forthcoming within 30 days from the filing of the petition.
So when the framers of the Constitution used the phrase may review, was this an unintentional mistake on their part?
Your Honor, we have to read the full context of that section, paragraph 3 of section 18 of Article 7. And the full impact of that provision is that it is a mandated jurisdiction for this court to review in a petition filed by any citizen.
Now, the Constitution provides that the Supreme Court may review the sufficiency of the factual basis. The law speaks merely of sufficiency. Can you speculate why the framers of the Constitution did not make the use of a precise language by saying the correctness, the validity, the truthfulness? What is your understanding of sufficiency of the factual basis?
That gives a wider jurisdiction on the part of the Supreme Court to assess the validity, the correctness, because validity and correctness would be subsumed under sufficiency. If the factual basis is correct, then it is sufficient. If the factual basis is valid, then it is sufficient. But if it is not correct or valid, then it is insufficient.
All right. The Congress has already given its full support to the executive department to the declaration of martial law. Can you enlighten the court whether the summary executive deliberation made by the House, was it done sub rosa? Were you excluded? Were some of the petitioners excluded from participating in the deliberation?
No, Your Honor. We were there. We participated. I participated, and I had made a statement that my participation will not in any way deter from my position that this was not the proper proceedings being taken by the House of Representatives, because under the Constitution there is a need for the House and the Senate to convene in joint session and jointly vote whether or not to revoke the declaration of martial law.
Now, the Senate similarly gave its support. The essence of democracy is the rule of the majority. The minority might be disgruntled, but we have to respect and obey the mandate of the majority. Now, the executive department has made a determination that there is a factual basis to declare martial law. Congress, the other branch of government, has also made a factual determination that there is factual basis for martial law. You are now before this court, the third branch of government, asking us to set aside the determination of Congress, the determination of the President. On what basis? Solely by examining the documents submitted to us. But you are not suggesting that we hold the trial to receive evidence, to receive factual evidence to make a determination of the sufficiency of legal basis.
The evidence on sufficiency, Your Honor, is extant in the very proclamation and report, Your Honor. And may we say that both the political departments of the government have violated the Constitution. The President, in not having a factual basis for the declaration of martial law, and the Congress, both the House and the Senate, in supporting the President's declaration because of a supermajority without following the mandate of the Constitution to have a joint vote in a joint session. So it is now for the Honorable Supreme Court as the final arbiter to resolve the issue we have raised, Your Honor, on the sufficiency of the factual basis for the declaration of martial law and the suspension of the writ of habeas corpus. Because this court, under the additional jurisdiction granted by the Constitution under Section 18 of Article 7, can precisely make that determination and adjudication. Because the action of the President, the action of the Congress should not preclude this Honorable Court in exercising its mandated jurisdiction.
Will it help to preserve the system and authority of our government if this court will be asked to override the collective wisdom of its co-equal branches?
Your Honor, there has been several instances when this Honorable Court has declared
We are not talking
a law.
of other cases, Your Honor. We're talking of this particular case.
Yes, Your Honor,
the
but
declaration of martial law.
I have to give some antecedents where the Supreme Court, despite the fact that the Congress is a co-equal body, has struck down laws which the Supreme Court deemed to be unconstitutional. In the same manner, Your Honor, that the Supreme Court has declared as unconstitutional in several instances actions of the President, like the creation of the Truth Commission, which this Honorable Court declared as unconstitutional. So this court has the plenary power, Your Honor, under the doctrine of checks and balances to correct and check the abuses which the political departments may do.
All right. When we face the Filipino people and tell them whether there is sufficient basis for martial law, you have a president, the commander-in-chief, the executive, the chief executive, with all the resources available to him, telling the Filipino people that there is factual and legal basis for martial law. Then we have Congress representing their various constituents, the senators and the members of Congress, telling the Filipino people that we have evaluated and we have found, the majority found, that there is factual basis, legal and factual basis for martial law. Now here is the Supreme Court. If we say otherwise and say there is no legal basis, there is no factual or legal basis for the declaration of martial law, and we are asked on what basis, we say on the basis of our judicial expertise, on the basis of the Constitution, solely on the Constitution. Because it says factual basis. The Constitution demands factual basis. So going back to my original question, you want us to go to trial to make a complete determination of the factual basis of the sufficiency, whether there is rebellion in this particular case that would justify our pronouncement that there is nullity in the declaration or validity in the declaration of martial law.
Your Honor.
So that is the scenario I'm trying to project,
Yeah.
Congressman Lagman, because
yes, Your Honor.
it's difficult to convince the Filipino people.
Your Honor, firstly, this honorable court should not temporize in making a decision or adjudication of this issue, despite the fact that it could be contrary to the position of the executive and the Congress, because it is precisely the mandate of the Constitution for this Supreme Court to make such adjudication. I think the decision of the President, the decision of the Congress should not preclude this honorable court to make such adjudication. Number two, with respect to the reception of the people, we have cited in our oral arguments the survey of the Pulse Asia, the latest survey, and that survey would show that 74% of the Filipinos nationwide, across all regions, economic and social classes and gender, that they are against the imposition of martial law. And the highest level of distrust and rejection of martial law is in Mindanao, where the President declared the entire region as under martial law. So it would not be difficult for the people to accept a decision nullifying the declaration of martial law.
Thank you, sir. You have my highest respect, as usual, and of course the other counsel for the petitioners, most of whom have appeared before me when I was a regional trial court judge. Thank you, Chief Justice.
Thank you, Your Honor.
Justice Peralta.
Yeah, for clarification, Congressman. Now, you do not admit that there is now public uprising in the Marawi city?
There is public uprising, Your Honor, but there is no rebellion.
Yeah. There's also taking up arms against the government. Do you also admit that?
Yes, Your Honor.
Yeah.
We agree to that.
What
but
you are saying is that, because you believe that, what you are saying is that there are three essential elements of rebellion. One is public uprising. Two is taking up arms against the government. what you are disputing is that the purpose of a public uprising and taking armed guards to government is not political.
No, we are saying that the essential element of culpable purpose is not present.
That's correct. That's what I'm saying. So the purpose of the violence or the taking of arms against the government is not political in nature.
Yes, Your Honor, we can
Yeah.
say that because it is merely to sow fear and
Yeah.
apprehension.
Yeah.
on the
Why,
part of the
why do you
citizen.
say the purpose is not political? May I know why you are saying that the purpose of the violence or taking up arms against the government is not political?
Well, we just agreed with your statement, Your Honor. But if we see the context of the present violence in Marawi City, there is no culpable purpose of removing Marawi City from the allegiance to the Republic, or there is no culpable purpose of depriving the President to exercise his powers and prerogatives because the channels of civilian and military authority
Is it
have
not
not
that,
been disrupted.
By the extent of the violence committed, Mr. Congressman, the chief executive is deprived of his power to enforce the laws in Marawi City?
At the time the proclamation was issued, Your Honor, there was no such kind of magnitude in the violence. No less than the military officials, hours before the President issued the proclamation, said that the situation is under control. What we should disabuse the mind of the public, Your Honor, is that what is happening now in Marawi City is the aftermath of the declaration of martial law, which was not the reality on the ground when martial law was imposed.
The chief has a question.
Yes, just for an administrative matter. Congressman Lagman, stay where you are. May I just request Solicitor General Calida to please approach the mic? Solgen, this is just so that we will have an efficient afternoon session. Yesterday, the court requested you to submit all memoranda, operational guidelines that may have been issued by the President, Secretary Lorenzana, or the implementers of martial law. And you had submitted yesterday the General Order Number 1 and a memorandum from the Undersecretary of the Department of National Defense.
Yes, Your Honor.
May we request, please, that you kindly also submit Arrest Order Number 1, dated May 29, 2017, from Secretary Delphine Lorenzana, Department of Justice, Department Order Number 385, June 7, 2017, from Secretary Vitaliano Aguirre, and any operational directives for martial law implementation issued either or by the Chief of Staff of the AFP and the Chief Director, the Chief of the Philippine National Police.
Yes, Your Honor. We'll do
And
that.
any
Your Honor.
other operating guidelines that may be there. May I request Solgen Calida to kindly contact these people immediately, and if the justices can have in their desks by 1 o'clock these documents as well as any other documents that may be existing, because for our resumption of the session this afternoon. Thank you, Solgen.
We will try our best, Your Honor.
Thank you.
Thank you.
All right.
Your Honor,
Yes.
with respect to that administrative matter, is it possible if we could request the Honorable Court to direct the Solicitor General to have the Administrator of Martial Law, Secretary Lorenzana, to be present this afternoon, and also the implementer of martial law, the Chief of Staff, or his senior representative.
What is your comment on that, Solicitor General?
What is the, may I know what will be the purpose for their attendance here?
Congressman?
Your Honor, they are the principal actors now with respect to the implementation of martial law. Secretary Lorenzana is the administrator of martial law, and the Chief of Staff, or the Chief of Staff is the implementer of martial law under General Orders Number 1. And I suppose that presence here would be important because this Honorable Court may want to ask questions with respect to the issuance of declaration number, proclamation number 216. If they are not available, then their senior representatives can be present. For example, if the General Anyo is not available, then his deputy, Lieutenant General Salvador Mison Jr. can be made available.
Mr. Solicitor General, your comment?
First of all, Your Honor, I'm not sure whether they are in town or not. Secondly, it will be my turn after the interpellation is over with respect to the Petitioners' Council is concerned. Now, is it the suggestion of my compañero that while I am delivering my opening statement, he will be asking, the court will be also asking our resource persons?
Allow me to just refresh everyone's memory. In all the important oral arguments that we have conducted, we have several times already requested high-level officials to be present. So this is not actually very strange. So may we know, considering that context, your further thoughts on the matter?
We will try to contact with them, Your Honor, but I think it is more doable if we can set it tomorrow, Your Honor, because I'm not sure whether they're available this afternoon.
Tomorrow then, Congressman Lagman, these are very, very busy people.
Yes, sir.
So we appreciate, thank you very much, the cooperation of the Solicitor General on this matter.
May I also request, Your Honor, that the briefing be done in privately, Your Honor, because there might be national, for reasons of security, Your Honor.
Your Honor, we will cross the bridge when we come to it.
It's
Because we have
better, Your Honor, that we
reservations.
decide now, Your Honor. So
We
that,
have reservations, Your Honor, with respect to accepted sessions because of our experience in the House of Representatives. There was an omnibus executive session, and during the proceedings, no confidential matter affecting national security was disclosed.
well, he cannot use his experience in Congress and assume that it will be done here also, Your Honor.
Solicitor General and Congressman, we will discuss this during the session break that we will have over lunch, whether it will, but we had already discussed several times, even during the preliminary conference, the possibility of an executive session.
Yes, Your Honor.
Now, with respect first, before I lose my train of thought on the matter of the documents, Mr. Solicitor General, you can actually convey to the court what matters are confidential or not, the degree of confidentiality, so that we may discuss among ourselves whether the status that those documents will have as far as the court in this case is concerned, and whether who will have access to such documents. In which case, also, if you formally manifest that the briefing will be done in executive session, kindly do that and indicate to us the level of confidentiality that must attend that executive session, as well as the presence of petitioner's counsel, because remember that this is in a certain sense, petitioners are actually entitled to know. But to what extent they need to know, that is a matter that you can convey to us, Mr. Solicitor General.
Yes, Your Honor, I will do that, Your Honor.
Congressman Lagman, you have any further thoughts on the matter before we discuss this?
We subscribe to the directive of the Honorable Chief Justice.
Okay. So that is then understood that tomorrow the administrator and then implementers of martial law shall attend through the cooperation of the Solicitor General, and we appreciate this very much, sir. And Congressman Lagman, we believe that if there have been matters that you thought were not really confidential during the executive session, we do not foreclose the possibility that there may be very highly classified information that will be conveyed to the court this time. So thank you, sir.
Thank you also,
Okay.
Your Honor.
So we will resume with the interpellation of Justice Peralta. Thank you.
We therefore agree, Congressman, that there are two political purposes of rebellion. One is the removal of the allegiance from the government or any part of its laws. That's number one. Number two is the deprivation of the chief executive or the legislator in the exercise of its powers and prerogatives. Am I correct?
Yes, Your Honor.
Yeah. And then you said that presently there is now a factual basis of the existence of rebellion, because it would be impossible now for the president to exercise its power or the power of enforcing the laws in Marawi because of the extent of the violence. Did I get you right?
Your Honor, I think that was not my statement.
Okay,
There is
so-
now a factual basis for rebellion.
Okay. Now, do you agree now that the president cannot now exercise its power to enforce the laws because of the extent of violence in Marawi City?
Well, even without declaring martial law, Your Honor, the violence and terrorism in Marawi City did not preclude the president from exercising his powers and prerogatives because the channels of civilian and military authority are there.
But I thought you said a while ago that there is no question that there is now public uprising.
Yes,
You
Your
also
Honor.
said that the violence, the taking up arms of government is already there.
Yes, Your Honor.
So all the essential elements are already present.
No, the culpable purpose is not there.
So what's the culpable purpose
The
that's not
culpable
there?
purpose, Your Honor, of rebellion is to remove the Philippines or a part thereof from allegiance to the Republic, or to prevent the President or the legislature from exercising its powers and prerogatives.
So what would you like the president to do under these circumstances?
Under the circumstances, Your Honor, he has done what he's supposed to do, except the fact that he declared martial law, because he could call the armed forces of the Philippines to subdue this terrorism being perpetrated.
Despite the presence of public uprising and taking up arms against the government.
Your Honor, the presence of an uprising, the presence of taking arms against the government is only one of the elements.
That's what I'm saying.
It does not conclude or presume that the other element is present.
No, that's what I was saying. How can the president exercise or execute the laws under these circumstances?
Your Honor, he can, and he has been doing that, Your Honor.
How?
Because the channels of civilian and military command has not been broken, Your Honor.
Okay.
As a matter of fact, the LGU of Marawi City, the LGUs of the entire Mindanao region are existing and operational. He can exercise his prerogatives and powers through the channel of this legislative, of these local government units, including the functioning departments of the government.
Okay, I go to another point. You agree that the crime of rebellion is a continuing offense?
Well, yes, there are jurisprudence to that effect, Your Honor.
In other words-
but I would say that rebellion should not be extrapolated.
No, I'm not after that. The other meaning of continuing offense is that several acts are committed in different places, but the purpose is the same.
Yes,
Do you
Your-
agree with that?
Yes, Your Honor, but in this particular case, the acts are not being committed in other places.
No, I'm not going to that yet. I will ask the question later, Congressman. That is the principle of continuing offense. You agree with that?
Yes,
That's also
Your
the
Honor.
other principle of continuing offense?
Yes, Your Honor.
That several acts might be committed in different places,
Yes, Your Honor.
but the purpose is the same?
Yes, Your Honor.
Yeah. Now, if, assuming, this is hypothetical, assuming that there is rebellion in Marawi City, and some of the acts are committed outside Marawi City, supposing the guns come from the nearby town of Marawi City, and the other members of the rebel group are based in that place, and they bring the guns to inside Marawi City, will that not be a rebellion in the other place?
In the first place, Your Honor, that hypothetical question is not actually happening in Marawi City, in
Oh, that's
other
all.
parts of the Mindanao region.
Supposing it happens. Supposing it happens. Will that be covered by the principle of continuing offense? That the acts are committed in another place and the actual rebellion takes place in another place?
When
All of them will be liable under the theory of conspiracy.
When we say, Your Honor, that it's a continuing offense, that rebellion is a continuing offense, it assumes that the inculpatory elements of rebellion are present.
Yeah, of course, we assume that. That's why it's hypothetical. Now, if there is a rebellion, I will not use any more Marawi City, because it might be, you might be presuming that I'm in favor of martial law in Marawi. Supposing in one place there is a rebellion ongoing, the declaration is to cover the whole area, outside even the place where the actual rebellion is happening. Can the President likewise cover the other areas nearby as part of the declaration of rebellion?
Your Honor, that may not be legally and constitutionally possible because with respect to the other areas, there is only an imminent danger of a rebellion, and imminent danger has been deleted
What
from
I
our
understand,
Constitution.
what I understand from the deliberations about imminent danger is the initial declaration of martial law should not be based on imminent danger. Because if there is already a declaration of rebellion, do not anymore ask or require imminent danger. Because if there is a rebellion in one place, let's say in Marawi City, and then the rebels will go to the other place committing rebellion, the President will issue again a proclamation in that place,
Well,
and then declare martial laws in order to suspend the writ of habeas corpus in other place?
when we say, Your Honor, that the President declares martial law or suspends the privilege of the writ of habeas corpus, there must be an actual rebellion in the place occurring. When there is no actual rebellion in the other places because there is only a possibility that it will spread there, I think that would be subsumed under imminent danger, which is not anymore a ground.
Can he not declare rebellion in Mindanao because Marawi City is part of Mindanao?
Your Honor,
You are suggesting that for every town that there is rebellion, a declaration should be made?
we are saying, Your Honor, that martial law can only be declared when there is actual rebellion
No.
for in the coverage of the President's proclamation.
Yeah, because what I understand from the imminent danger, the reason why it was removed is that in the initial proclamation of rebellion under the old law, you can use that as a ground. But if the proclamation is rebellion, that's it. It's in accordance with the Constitution.
Rebellion, Your Honor, with respect to the place which is covered by martial law, not to other places where there is no rebellion or there is only a threat.
But if the President declares Mindanao and Marawi City is part of Mindanao, what's wrong with it?
Your Honor, Marawi City territorially is only 0.0% of the entire Mindanao.
But the groups who are involved are located in several places in Mindanao. Some are based in Davao, in Lanao, based in Davao, based in Basilan, based in Sulu, all of these places.
That is only a threat. because of their presence there, but they have not activated, Your Honor.
Well,
In
that's
other
what-
words, a threat is akin to imminent danger, which is not a ground.
No, it's not. What I mean to say is that the President declares martial law in Mindanao. Will that not cover the whole Mindanao because rebellion is taking place in Mindanao?
Your Honor, that has no factual basis. The sufficiency of the basis of that declaration is not there because there is no rebellion in the other parts of Mindanao, particularly the areas mentioned yesterday by some members of this honorable court.
Okay, so the President should specifically declare a certain place where the actual rebellion is happening.
Yes, the
So if the
Constitution, Your Honor,
rebellion will spread to the other towns, the President must again come out with a proclamation declaring martial law in that place.
Well,
Is
if there is
that your theory?
if there is
Counsel?
actual rebellion in the other places,
Yeah,
Your
there is
Honor,
actual rebellion in the other place. So the rebels are now in a certain place. They now expand the rebellion in the nearby town. So the President will declare another proclamation in that nearby town. If we follow the theory, that there is no yet imminent danger. So he can only declare martial law when the actual rebellion already takes place in that nearby town.
we are just following the intendment of the Constitution, Your Honor, that there must be actual rebellion as
Yeah.
the basis for the
Of
declaration
course,
of martial law.
that's always the requirement. There must be actual rebellion. Thank you.
Thank you, Your Honor.
Thank you.
Justice Carpio.
Counsel, what powers do the President acquire under martial law that he cannot exercise without martial law? Let's say martial law, but there is no suspension of the privilege of the writ of habeas corpus. So, because we're talking here of how should the President respond? Call out the armed forces, or proceed to the last defense, martial law. Now, so what are the powers that the President can exercise under martial law that he cannot exercise without martial law?
Well, actually, it is not the exercise of powers, but when martial law is declared, the role of the President as Commander-in-Chief is of utmost primacy. So much so that this would embolden the armed forces to make certain actions which may be detrimental to civil liberties and human rights.
Well, the President, whether under martial law or not, remains the Commander-in-Chief.
Yes, Your Honor. But
So, but there has to be something different when it is when Marawi, for example, assuming it's under martial law, there must be something different when it is not under martial law. What would that be, Counsel?
that would be the primacy of the role of the President as Commander-in-Chief, Your Honor. And the martial law has been made synonymous to military rule. And
So, under the Constitution, when the President declares martial law, for example, in Marawi, let's assume that he properly declares it with the right conditions, correct, sufficient factual basis. You're saying that there is military rule in Marawi City. That is the effect of martial law.
Yes, Your Honor.
What is your understanding of military rule?
Well, it's the exercise by the military of extraordinary powers which may affect human rights and civil liberties of the people under the cover of an enabling purpose of martial law.
Does military rule mean that civilians can be subjected to military tribunals in that place?
No, Your Honor, that is prohibited by the Constitution.
So it's, well,
but
under-
as we have said, all of these safeguards will only be good if the President and his military commanders would respect these safeguards.
The situation envisioned in Ex parte Miligan will not apply here, where the court said there can only civilians can be subjected to military tribunals only if the civilian courts are not functioning. But under a constitution, civilian courts must continue to operate, correct?
That's correct,
So
Your
it's
Honor.
not constitutionally possible.
That's correct, Your Honor.
So what is now the difference between martial law and no martial law in Marawi?
The difference, Your Honor, is, as we have said, the primacy of the role of the President as Commander-in-Chief,
But he's
which
always-
would embolden military forces to do acts which may contravene the Constitution.
So there are no legal powers, additional legal powers acquired by the President when he declares martial law.
No, Your Honor. I could not mention at the moment any additional
Yeah.
powers
Assuming he
which he
doesn't
would
suspend
acquire.
the privilege of the writ of habeas corpus. So there is no additional power granted by the Constitution to the President when he declares martial law. That is your understanding.
Well, except the primacy of his role as Commander-in-Chief is
But what is
being-
that primacy? How do you concretize that?
Well, he could issue orders and memorandums and memoranda to the military, which ordinarily he may not do.
But he can always do that.
Yeah, ordinarily he will not do that. But in the case of a regime of martial law, he can do that.
But he can always issue orders to the military. I mean, he's a commander-in-chief. So, because we keep on talking about martial law, so I want to know what will be the difference if the President declares martial law correctly, factually, sufficient factual basis in Marawi, and when he does not declare martial law. What would be the additional powers that will be acquired by the President or granted to the President under the Constitution?
Well, it's the ascendancy of military rule.
It's just psychological, that's what you're saying.
It's both psychological and real, Your Honor.
Yeah, real, but legally, no additional powers are accumulated by the President.
Well, under the state of the law of the Constitution, I don't think there is
There
any
is.
additional
There is.
power.
There is no additional power acquired by the President by declaring martial, assuming he does not suspend the writ of habeas corpus.
Yes, Your Honor. But
There's really no, we're just quibbling over something that doesn't really matter legally. That's the effect, if he doesn't acquire any additional legal power.
well, he may not assume any legal power, but the Constitution requires him to have sufficient factual basis for his declaration of martial law.
Okay, I hope you will expound on that in your memorandum of counsel, because I think we have to clarify the scope of martial law. I mean, does it alter the legal landscape in the country? Does the President acquire additional powers under martial law? Thank you.
Justice De Castro.
This is just a follow-up of the question of Justice Peralta. I'm thinking about the objective, the political objective of a group or a terrorist group, and the ability or the capability of the terrorist group to rise up in arms against the government. For instance, the objective of this group is to also take over the surrounding cities and provinces near Marawi, and that is the objective of this group. But they have succeeded in rising up in arms only within Marawi City. Are you now saying that the President can only declare martial law in the surrounding city if this group is able to rise up in arms in another city, which means that martial law should be declared individually in each of the cities and provinces where they are able to rise up in arms, even if the political objective includes all of the surrounding areas? Are we not going to look into the objective of that organization or that group?
Well, Your Honor, precisely we are disputing that the objective of the Maoti and the Abu Sayyaf group is to remove the Philippines or a part thereof from allegiance to the Republic, or to deny the President or the Congress to exercise its powers and prerogatives. To our mind, there is no factual basis for that conclusion. So in other words, we comply with what the Constitution mandates, that for martial law to be declared, there must be actual rebellion or invasion when public safety requires it.
Well, in that situation where the political objective, assuming that there is such a political objective, which I think it should be the Solicitor General should be able to prove that the political objective of this group is to take over the rest of Mindanao, but they have only started doing it in rising up in arms in Marawi City. Does it mean that the President will have to wait until they are able to wreak havoc or rise up in arms in the surrounding cities before the President can declare martial law?
Your Honor, the President did not wait for that havoc to happen, because under the Constitution, he can call the armed forces of the Philippines to subdue lawlessness, rebellion, or invasion. So he does not even have to declare martial law in those other places, Your Honor, because this threat can be preempted by the armed forces of the Philippines.
Assuming that, well, let's leave it at that, because the circumstances may be such that it may demand something more than suppressing lawless elements by calling the armed forces, but we need to find that out from the Solicitor General. Another question that I'd like to ask is, you mentioned that anyway the President is not yet is still able to perform his function in Marawi City. Are you trying to say that he will have to wait until the rebellion is successful before acting? Or because you said, well, it's still the local government is still there, they are still functioning well. Are you saying that the President should wait until this group is successful in achieving, in doing that?
Far from that, Your Honor, we are not suggesting that, but we are just stating a fact that despite these terrorist acts of the Maoti group, the President is not prevented from exercising his prerogatives and powers, because the chain of command, both civilian and military, have not been broken. For example, the LGUs of Marawi and even the entire Mindanao are functioning and operational, and it is through these LGUs and the other departments of the government where the President exercises his powers and prerogatives.
You're not saying that he has to wait until that time that this group is successful before taking any action or declaring martial law?
He does not have to do that, Your Honor. He does not have to wait under that these terrorist groups would succeed, because under the Constitution, he can call the military to subdue lawlessness, rebellion, and invasion.
Justice De Cas, Justice Leonen.
I will defer to Justice I'll defer to my senior
Okay,
justice.
Justice Bersamin.
Thank you. Thank you, Chief. I meant to ask you something about the law out of curiosity because we have been talking about rebellion. It must be actual. That's your contention. Congressman Lagman, is there a crime of attempted rebellion? As far as you are concerned, as a lawyer?
I honestly, Your Honor, I have no knowledge of the gradation of rebellion from attempted, frustrated,
Yeah.
and consummated. It's
Yes.
always something which is consummated.
Consummated. So we will not talk about attempted rebellion, we will not talk about frustrated rebellion. Because if rebellion succeeds, there is no longer any need to talk about a rebel.
Well, Your Honor, before it succeeds, I think government has all of the resources
Yes.
to subdue rebellion.
Yes, that's why, the reason why I have asked that is your contention that it must be actual. So this is a rebellion that must be quelled still. It has not yet succeeded, but
Yes.
it is already ongoing.
Yes. The Constitution requires that, Your Honor.
Yes.
That for a rebellion to be used
Yes.
as a basis for martial law, it must be actual.
That's why-
Because the Constitution already removed imminent danger.
Yes, that's why I was asking Attorney Cortez yesterday if he should not grant to the President the good faith that he is entitled to as a public official, the Chief Executive and Commander-in-Chief. Shall we not presume that his reading of intelligence reports, which is his job to do, should be accorded the highest respect?
Yes, Your Honor. That presumption is there. The presumption of regularity. But that presumption is disputable.
Yes.
It is for this reason that that the Constitution granted this honorable court the power to review
Yes.
the actions of the political departments, and in this particular case, to find out whether there's actual sufficient basis for the declaration of martial law. Because otherwise, if we give that a 100% conclusiveness, then there is no more action which the Congress or this honorable court will have to do.
No, I'm not suggesting at all that we buy it absolutely, hook, line, and sinker. But what I am just saying is, we are examining here the factual basis. We may have a different view of things, but at least we have to start from presuming the President to have acted well within his prerogative as Chief Executive, Commander-in-Chief, etc., and give him that presumption. And that will lay the burden on whoever challenges it, that citizen mentioned in Section 18 of Article 7. Whoever that citizen is, or maybe the petitioners now here are among those citizens who challenges, should come forward with matters or facts or knowledge that we do not have, which will help us determine if the President had sufficient basis, factual basis.
Your Honor, we suggested to the honorable court yesterday and today that in the assessment and review of the sufficiency of the factual basis for the President's declaration of martial law should be based on two fundamental documents, and these are Proclamation Number 216 and the President's report to Congress. Because under those two reports, this President would submit that there is actual sufficient factual basis. But we refute that, Your Honor, and we have said why there is no factual basis, because in the first place, the conclusions of facts and law in these two documents have no verifiable basis, Your Honor. The President only cited the Article 134 of the Revised Penal Code, and he cited the culpable, the inculpatory elements there, and then there
Yes,
was a
yes.
conclusion. already.
Now I have this opportunity to ask you myself. I was interpolating another petitioner's lawyer yesterday, but now that you're there, may I ask you this? A proclamation, like this proclamation we are talking about now, how many pages shall it contain? Or where should we find the facts that you want to find in order to support the proclamation? Should they be in the proclamation itself, or should we be satisfied to read these facts or know these facts from the report of the President to the Congress? How many pages? I asked that yesterday. How many pages should a proclamation have in order to satisfy this looking or searching for what justified the proclamation?
Your Honor, the length of the proclamation
Is irrelevant.
and no, Your Honor, the length of the proclamation and the assertion of facts therein is the call of the President.
All of them. Thank you. Thank you. That's what I was after. Thank you, Chief.
Justice Leonin.
Congressman Lagman, I just have a few questions. And I was curious that in your opening statement, you mentioned that prior to the declaration of martial law, there was an all-right signal from the Department of National Defense. Everything was under control. The AFP also said that everything was under control. Then when the declaration of martial law came out, suddenly nothing was under control. Am I correct? Was that your statement?
Well, yes, Your Honor, because our statement is based on the assessment made by the military establishment hours before and contemporaneous with the declaration of martial law.
In fact, you had a timeline that indicated how many hours before martial law, and then after the declaration of martial law in Russia or here in the Philippines, that there was a shift in the opinion that was stated by the Department of National Defense and the AFP. Am I correct?
Yes, Your Honor, but that is a fact or an assertion after the declaration of martial law,
Okay.
which facts would not be an input in
Yes.
the declaration of martial law.
Just some quick questions. Can martial law be used to address illegal trade in drugs?
No, Your Honor, because the basis of martial law will only be the actuality of rebellion or invasion.
And as a matter of fact, if there is a directive from any of the administrators that illegal trade in drugs, let us say in Eastern Mindanao Command, is going to be addressed, that it lacks factual basis because it is neither in the proclamation nor in the report of the President. Am I correct?
Yes, Your Honor.
By the way, there are two operational commands, correct? Two unified commands in Mindanao. You have the West Mincom and you have the East Mincom. And Marawi is within Western Mindanao Command, so is Sulu, Basilan, Maguindanao, etc. The Eastern Mindanao Command contains some of the areas which I mentioned yesterday, Camiguin, Surigao, Agusan, etc. But in any case, just a point of clarification. Can martial law, this martial law declaration, be used to degrade or weaken the NPA? Can this martial law declaration be used in any of its operational directives to degrade or weaken the new People's Army?
Your Honor,
Or maybe I should rephrase that. Is there factual basis in Proclamation 216 or in the report of the President to Congress that will underscore or support the purpose of martial law, which can be to degrade or weaken the NPA?
there is nothing there, Your Honor.
What about to degrade or weaken the NPA so that they are kept at the peace table?
There is nothing there about...
So if it is in an operational guideline, then that would be unconstitutional. Would you agree with me?
Yes, Your Honor, because
Okay.
it is not consistent with the declaration.
What about a directive from any of the officers in charge, administrator, implementer, that the martial law declaration shall be used for peace spoilers in quotation mark, peace spoilers.
Spoilers.
Can that be the purpose of this martial law declaration? Again, maybe I'll rephrase that. Is there factual basis in Proclamation 216 or in the report of the President that martial law can be used anywhere in Mindanao in order to quell the peace spoilers?
Well, there is nothing there in that proclamation or the President's report.
Okay. What about in order to investigate some senators and other opposition leaders?
And there's definitely, Your Honor, there's nothing there.
No factual basis in the proclamation nor in the declaration, correct?
Yes, Your Honor.
As a matter of fact, that is located within the fringes of constitutionality. Am I not correct?
Yes, Your Honor.
Yes. What about lawless violence in general? Can this be the target of martial law? Or let me rephrase that again. Is there factual basis to say in the from 216 or the declaration of the President that this martial law declaration can be used for lawless violence in general?
Well, Your Honor,
Such as carnapping, such as illegal possession of
Your
firearms?
Honor, it cannot be because the Constitution requires that the basis for martial law should be the actuality of a rebellion or invasion when public safety requires it.
Let me be clear. If Proclamation 216 is general, we will know the extent of the declaration with the operational guidelines. Am I not correct?
Yes, Your Honor.
Okay. Can media be controlled or suggested or requested to do something under martial law?
No, Your Honor.
If it is contained in a general order, is that constitutional?
That's not consistent with the Constitution.
Even
Your
if it's
Honor.
in Section 6, General Order Number 1, where it actually says that there is a request to the media to do something either for or against the proclamation. Would that be unconstitutional?
That is not consistent with the Constitution, Your Honor.
Yes. Do you know whether it's in General Order Number 1? Section 6.
I don't have a copy of the same. I have read that
I
already.
put a
but-
copy in the screen. The role of the media is vital in ensuring the timely dissemination of true and correct information to the public. Media practitioners are therefore requested to exercise prudence, etc. Is this in a martial law general order in this day and age under this Constitution? Would this be the proper content of a martial law general order?
It is a veiled media censorship.
And there are decisions of this court, particularly Bob's versus National Intelligence Board during the martial law court, which clarify that certain kinds of communications to the media amount to could have a coercive effect. Am I not correct?
Yes, correct, Your Honor.
Yes. Okay, now, let's go to Proclamation 216, the folio of Proclamation 216. It says there, habeas corpus, or the privilege of habeas corpus is suspended. Am I not correct?
Yes, Your Honor.
Yes. In the Constitution, in paragraph 5 of Section 18, can habeas corpus be suspended globally for all crimes? Or is it limited to rebellion and anything directly connected with rebellion?
It is limited to the actuality of rebellion or acts related to rebellion.
Can we determine the sufficiency of factual basis of an act which is broad and unconstitutional?
Well, if it is that it is vaguely broad, then it is not adequately or sufficiently anchored, Your Honor.
Okay. Let us go to General Order Number 1, more particularly the provision on arrests, which is section, can we scroll it down? This is General Order Number 1. It specifies the broad provisions in Proclamation 216. Section 3, Scope and Authority. Notice, the armed forces of the Philippines shall undertake all measures to prevent and suppress all acts of rebellion in the Constitution and lawless violence in the whole of Mindanao. Then there is, including any and all acts in relation thereto, then in connection therewith, then or in furtherance thereof. Is that, can we determine the factual basis of this provision? In other words, is this...
The factual basis of this provision cannot be traced to the proclamation of the President's report.
or in the report of the President?
Yes, Your Honor.
I'm more concerned with the next paragraph. Further, the AFP and other law enforcement agencies are hereby ordered to immediately arrest or cause the arrest of persons and/or groups who have committed, are committing, or attempting to commit the above-mentioned acts. And the above-mentioned acts point to not only rebellion, but also lawless violence. Would you have any comment with this subparagraph?
That's an all-encompassing order for the arrest of persons, and under the Constitution, the right of a citizen from arrest without warrant is still maintained even when there is martial law, unless there could be a justification for a warrantless arrest.
That's why it's very important that we see the operational directives of the martial law implementer, the Chief of Staff of the Armed Forces, in order to particularly see what this means. Because this is simply a general order from President Duterte. Am I not correct?
Yes, correct.
Yes. Now, are we limited here to determine the factual basis in relation to the declaration, or are we supposed to clarify what that declaration actually means so that we will know the facts that will probably support it or not?
Well, we said essentially the assessment should be limited to proclamation number 216 and the President's report. But relevant documents like the one we have mentioned, Your Honor, can be also part of the assessment.
Okay, maybe as a final question, those who sit in this bench, this Supreme Court, should we be judged on the basis of how personally we trust the President of the Republic of the Philippines as a sitting president? Or should we be judged as to how loyal we are to the words of the Constitution, regardless of the personal consequences, because that is the voice of the sovereign? What do you think?
Well, Your Honor, I think the Honorable Supreme Court should exercise its mandated jurisdiction in fealty to the Constitution.
Because the immunities given to us are to give us courage in order to be able to protect the words and the spirit and the relevance of the Constitution. Am I not correct?
Yes, Your Honor, you
Thank
are
you.
most correct.
Attorney Manuel, please. Thank you. Congressman, please just
you.
stay there for a while.
Yes, Your Honor.
I have already, I am curious, you are the one who raised the statement of the IBP Lanao chapter?
It was Congressman Edsel Lagman, Your Honor.
Okay. So do you have personal knowledge of that, Attorney Manuel?
Yes, Your Honor. We have been informed about the statement, and we have a copy of the press statement. It's not the full statement, but it's the press statement of the IBP chapter of Lanao.
So you have heard yesterday that Congressman Lagman intends to submit a copy of that statement here.
Yes, Your
If he
Honor.
was the one who brought it up.
Yes, Your Honor.
So we expect that to be brought up here. But
Yes.
in contradistinction to the IBP Lanao chapter's statement is the IBP national officers' statement supporting the declaration of martial law. Is that correct? Is there such a statement?
I have heard that there was a statement, Your Honor. I have not seen the full statement of the IBP National.
All right. So you may have already also heard that I said that martial law can be also used for good.
Yes, Your Honor, and we agree with that.
jurisdiction here is not to say that martial law does not exist, legally exist, but it is to give fealty to the words of the Constitution when martial law can be declared.
Yes, Your Honor.
So, when you are saying that actually there is only one condition for the declaration of martial law and the suspension of the privilege of the writ of habeas corpus in response to the question of Justice Leonen yesterday, do I mean that when you were saying there is only one condition, Article 7, Section 18 should read as, and the relevant phrase, in case of invasion or rebellion when public safety requires the declaration of martial law or the suspension of the privilege of habeas corpus. That is how it should be read.
Yes, Your Honor. In fact, yesterday I said it's a continuous formula. The actual invasion or actual rebellion when public safety requires it, meaning the imposition or the suspension of the privilege.
So it's just a preference, whether you can say that it's one continuing formula or two concurrent conditions that must occur.
Yes, Your Honor. In fact, Your Honor, to be accurate, the Supreme Court is mandated to review not just the factual basis, but the sufficiency of the factual basis. So it is not enough to say that there is factually rebellion, actual rebellion, or actual invasion. The Supreme Court should also inquire into whether that existence of rebellion, actual or actual invasion, would be sufficient to require the imposition of martial law or the
Okay.
suspension.
So that our jurisdiction here is first to find out in one continuum, not in two distinct modes. First, the sufficient factual basis, not just factual basis, and that this factual basis must be sufficient. Those are actually alternative ways of presenting it, as
Yes,
long as we
Your
say
Honor.
that they are concurrent.
Yes, Your
So
Honor.
our jurisdiction is basically, if you're going to put it in one sentence, the court reviews whether there is sufficient factual basis for the declaration of martial law or the suspension of the privilege of habeas corpus in cases of invasion or rebellion when public safety requires the declaration of martial law or the suspension of the privilege of the writ of habeas corpus. That's a correct formulation?
Yes, Your Honor. That's the wording of the Constitution.
All right. So that is how I also understand our role to be. Now, however, in the penultimate paragraph of the three petitions that are filed before us, you have already said that you are also asking for other just and equitable reliefs. And during the oral arguments yesterday, Congressman Lagman has already brought out the possibility of human rights abuses through the statement of the IBP Lanao del Sur chapter, Lanao del Sur chapter,
Del Sur, yes,
and
sir.
the fact that in fact one of the fears that was being evoked by the declaration of martial law is that in fact there will be these human rights abuses. Is that what the session yesterday has so far elicited?
Yes, Your Honor.
In other words, it would be a just solution if, assuming we come to the conclusion that there is sufficient factual basis for the President to declare, etc., the long formulation I gave, is it also within our jurisdiction to define the limits of that declaration?
Yes, Your Honor. Because the necessity should limit the scope.
All right, the necessity should limit the scope. In other words, we will be compelled in these hearings to require the government to define for us what martial law powers entail that are not available in the two lesser modes of responding to invasion or rebellion.
Yes, Your Honor.
Including, and we cannot presume, that all the inhibitions that are imposed on the government, such as the non-suspension of the operation of the Constitution, the continuous functioning of all civil courts, the non-acquisition of military jurisdiction over civilians, the non-suspension of the operations of legislative assemblies, the non-operation of the Bill of Rights, the full respect for human rights, all of those are not, we do not presume that simply because the declaration of martial law has been invoked by the President by reciting Article 7, Section 18. We do not, and we should not presume that that is also the understanding of the government with respect to how martial law should be administered.
Yes, Your Honor. Those are limitations imposed by the Constitution.
So, if these are limitations imposed by the Constitution, it behooves us now, the necessity for the declaration of martial law, it behooves us therefore to delimit what government can and cannot do during martial law.
Yes, Your Honor. Similar to what the Honorable Court has done in Proclamation 1017, the Court said, you can do this, but you cannot do this.
In other words, that also assures petitioners here who have brought up the possibility of abuses and a return to the Marcos martial law regime, that it is in fact part of the duty of the courts to ensure the safeguard of the Constitution and the protection of the constitutional rights of its citizens.
Not only for the petitioners, Your Honor, and not only for this generation, but also for the next. This is a once in a lifetime opportunity for this honorable court to rule on this very novel issue. The first time in 3 decades from the 1987 Constitution.
And do you think that it is also our duty to remember the brave men and women of the AFP who, under a possibly misdirected order, can actually do acts for which they can be held eventually civilly and criminally liable?
Yes, Your Honor.
So it also behooves us to protect the AFP as an institution.
Yes, of course, Your Honor.
And we should not presume that martial law per se is a good for the AFP.
No, Your Honor.
Would you know whether there are in fact statutes that will put military officers and soldiers in hot water if they follow a presidential directive that turns out to be without sufficient legal basis?
We have what we call as the International Humanitarian Law, the statute in the Philippines. I'm not sure if it's 9831, if I'm not mistaken, which prohibits certain acts, even in armed conflict, and will hold military officers accountable and liable criminally under that statute, and even the commanding officers under the principle of command responsibility.
So this is not only international law, but it has already been incorporated into domestic law.
Yes, Your Honor.
And therefore, there will be no defense that international law does not reach the liabilities of those officers and men on the ground.
Yes, Your Honor.
So, on behalf of them, this court must also define the limits of what the President can direct.
Yes, Your Honor.
It is not that we are not aware that we have a duty to show utmost respect for the President, but we also need to understand that our men and women are out there dying, their lives being given up, heroic acts being performed, and they do not know the legal conundrum that they might face should this court fail to sufficiently outline for everybody the legal framework for which martial law should be administered in this country. Is that not correct?
That's correct, Your Honor. And I would like to add also that the Supreme Court should also provide the appropriate proceeding to look into the sufficiency of the factual basis. Your Honor, under the rules of court, we have a rule concerning proceedings for hospitalization of insane persons. That issue is covered by the procedures of the Honorable Court. Here, we are discussing a very important national public interest issue. And it would be very unfortunate for us to allow this opportunity to pass, for the Honorable Court to allow this opportunity to pass, simply because there are no clear procedures on how this will be done.
You are aware of the Human Security Act?
Yes, Your Honor.
Do you believe that if you are going to read the Human Security Act at first impression, it attempted to empower our security forces with sufficient authority to conduct surveillance and intelligence operations against terrorists?
Yes, Your Honor, subject to the approval process with the Anti-Terrorism Council and with the judiciary.
But you are also aware that the military and security establishment has been asking for the amendment of the Human Security Act because the liabilities that are posed there are quite, in their view, I don't know whether they are correct or not, onerous, burdensome.
Yes, Your Honor, if that is about the monetary penalty for wrongful conviction.
Indeed, in fact, it shows you that there could have been legislation to help our military forces, security forces deal with terrorism. But the sufficient legal framework, it is possible that Congress had not sufficiently legislated that framework to keep our men and women in uniform out of legal harm's way when they are conducting their work. Is
Yes,
this
Your
correct?
Honor. The guidance that the Honorable Court will include through a decision will also guide the military and the police, not only those who are on the field now, even their commanding generals, but also the future generations of soldiers and police officers.
So it is not a simple job of the court to simply say that Marawi is under siege, and on that basis immediately concur with the petition of the respondents that we immediately dismiss the petitions that have been brought before us. But rather, our job is more complex.
Yes, Your Honor.
If we do not rule correctly and do not provide the guidelines, then it is possible that this court will only add to the confusion
Yes, Your
rather
Honor.
than clarify a situation. And it is only a voice of clarity and sobriety that is most necessary in times of emergency.
Yes, Your Honor.
And it is, while the court is very concerned about the violence that is happening in Marawi, we must still protect the fabric that holds together our society.
Yes, Your Honor. There is no inconsistency.
And while we will and may uphold the power of the President, it is also our duty to ensure that that power is discharged fully in accordance with the framework that governs our country.
Yes, Your Honor. Definitely.
Otherwise, what will happen to this country, Attorney Manuel?
Then we will be destroying the institutions that had been built over several decades from the 1987 Constitution.
And what does it mean for us to destroy institutions, Attorney Manuel?
Then we are reverting back to the martial law period, Your Honor, during Marcos.
So we need to find out how we can get out of this emergency situation by trying to define for the President, with all due respect, what can be done and what cannot be done. And for this court must ensure that its examination of the factual basis is sufficient and thorough. And that factual basis is also likewise sufficient.
Yes, Your Honor.
Okay, so with that, these proceedings having been put into the context of a wider perspective that must be laid before the eyes of everyone, we will request, in fact, if in your memorandum, all the three petitioners' groups, as well as the memorandum of the Solicitor General, a very clear definition of what can be done under martial law will be outlined. And we will expect that they will be full and thorough, including liabilities attendant to those who are implementing or participating in orders issued under martial law. to include even the authorities of local governments to discharge their functions within the area of operation, including even liability for the disbursement of funds in pursuance of martial law objectives.
Yes, Your Honor.
So, thank you. Is there any further question from any of my colleagues? Justice Velasco.
Yes, Your
Yeah,
Honor.
I'll just ask you. I guess you're also hungry. Anyway, you admitted yesterday that substantial evidence is sufficient to show actual rebellion. Is that correct?
No, Your Honor.
And-
To be accurate, Your Honor, we are saying that substantial evidence should be the court's quantum of evidence in reviewing the sufficiency of the factual basis.
But in determining whether or not there's actual rebellion or rebellion as defined under Article 134, are you saying that proof beyond a reasonable doubt is needed before the chief executive can declare martial law?
No, Your Honor.
Then what kind of proof is needed to enable the chief executive to form a basis as for the declaration of martial law? What kind of evidence should suffice?
That's why, Your Honor, we said the substantial evidence will be for the concurrence of both the existence of actual rebellion and the necessity of imposing martial law or suspending the privilege of the writ. Because even assuming actual rebellion is there, we have to go beyond that. We have to look into the necessity for public safety of the imposition of martial law or the suspension of the privilege.
Okay, but I correct me if I'm wrong, but I think it's the position of the petitioners that the second element of the crime of rebellion was not sufficiently established, correct? The second element, which is the purpose of removing from the allegiance of the Philippine government any territory or part thereof, or depriving the chief executive legislature, etc. You're saying there was an admission yesterday. I don't know who from that petitioner is, that there is a public uprising or taking of arms against the government. Is that correct? I think Congressman Lagman said that, correct? Okay. So we now go to the second element. But you look closely at the second element, and the second element is the purpose of removing from the allegiance of the Philippine government any Philippine territory or part thereof, right? It is incumbent for the government, following your line of reasoning, that that purpose must be shown, must be proven. Is that correct?
Because the very proclamation, Your Honor, cites the definition of rebellion.
Yes, yes.
Under the
yes.
revised penal
But
code.
I'm looking at how we will address this issue, because we're dealing with factual issues. But you must admit that it's difficult to prove the purpose behind the commission of a crime. It is just a purpose. It is in the mind of the perpetrator or the one who is committing the crime. It is just a purpose. It may just be an intent. Are you saying that there should be an overt act that will show or manifest the purpose of the criminal? Is that your position?
In the crime of rebellion, Your Honor, if we are, assuming we are in a prosecution for rebellion.
No. We are not here trying a criminal case.
Yes, Your Honor. That's why I'm saying, assuming that we are, then
Okay.
that element cannot be proved by a subjective motive on the part of the accused in that criminal case. There has to be overt acts manifesting
Overt acts.
that element.
And what kind of overt acts do you think are needed to show the objective of removing from the allegiance of the government any part or territory thereof? What kind of overt acts, especially in this particular situation?
It will be a combination of various acts, Your Honor. For example, holding the chief executive of that city.
No, but that did not happen here. How about
Yes,
the
Your Honor.
occupation of the territory of Marawi City?
Occupation may or may not exhibit that element, Your Honor, of
May or may
removing
not.
from the allegiance. Yes, Your Honor. It can be an occupation of a building, for example, even if it would be City Hall, would not necessarily be proof that the intent was to remove allegiance. If you look at the Resorts World incident, Your Honor, there is a question now as to the real motive of the perpetrator. Was it just to get chips or to
So,
cause
okay, if you are
murders?
the chief executive, what kind of proof is needed that will serve as a basis for you to declare martial law and thinking that this evidence or proof or documents actually show that there is that objective of removing from the allegiance of the Philippine government any of the Philippine territory or part thereof? What kind of proof should be in the hands of the chief executive before he declares martial law?
That the military cannot do anything unless there is martial law. That the military cannot pursue whether they are terrorists or rebels. And therefore, there is a requirement, there is a need for the imposition of martial law and the suspension of the privilege. Because if there is no connection, Your Honor, between the suspension
Is that an
and
overt
the imposition.
act? Is that an overt act to show that the persons alleged to be committing rebellion have that objective in mind? That the military cannot perform its functions and control or effectively put a certain part of the country under its control?
No, Your Honor. I'm just emphasizing the point that in the mind of any president, for that matter, then the question that must be asked is, can the military do its function without imposing martial law? If not, then martial law would be necessary. It would be required by public safety. Otherwise, then the military is there, the military can do its job together with the police, then there is no necessity for martial law.
Okay. Suppose the chief executive receives an information from a government spy that shows that the objective of this group is to remove from the allegiance of the government any part of the Philippine territory. Will that suffice as a basis for declaring martial law?
I would say not yet, Your Honor, because the military can still do its job and pursue the terrorists or the rebels, even without martial law. Martial law will not add anything if the objective is to pursue the armed groups.
But is it not the fact that prior to the declaration of martial law, the Mauti group was in control of a certain part of the Marawi City?
Meaning before May 23, Your Honor?
Yes, before the declaration of martial law. The Mauti groups were in control of certain parts of the Marawi City.
But even other armed groups, Your Honor, NPA for one, Your Honor, are in control of some areas. But that would not justify the imposition of martial law in those areas.
But even the military had a hard time recapturing the areas from the Mauti group.
But even with martial law, Your Honor, they're having a hard time. That's exactly the point. Martial law will not add anything if the objective is to pursue the enemy.
Well, anyway, I just want to you to elaborate on these things again because the petitioners have been saying the two elements must be satisfied, and there's only an admission as to the first element. But the way I look at it, we really have to clarify
Yes, Your Honor.
how to satisfy the second
Yes, Your
element.
Honor. In fact, Your Honor,
Chief.
as we have mentioned earlier, it's not just the factual basis, but the sufficiency of the factual basis. And we go beyond, well, as far as the petitioners that we represent, the petition, we go beyond the mere existence of actual rebellion. We are saying, even assuming there is actual rebellion under the Constitution, that will not be enough. There has to be a showing that there is a necessity for public safety. And that will also limit the area of coverage. Because what may be needed for Marawi and maybe for the entire province of Lanao del Sur may not be needed for the Nagat Islands, which is very far in the other side of the that's in the Pacific. Yes, Your Honor.
Thank you very much. There being no further questions, this session is hereby adjourned for a lunch break to resume at 2 o'clock.